Hello everyone, welcome to VISHNU IAS. Today we are going to see another important recent current affair which will come in your GS2, okay, in your polity and governance category. Daughters have equal right to inherit property, says Supreme Court. Okay, so we are going to see everything about this by VISHNU IAS team. This was a landmark judgment given by the Supreme Court. Okay, so let's see in detail what is there in news. The Supreme Court expanded on a Hindu woman's right to be a joint legal heir and inherit ancestral property on terms equal to their male heirs. Okay, so what the Supreme Court has said is that as like the boys in a family, in a joint Hindu family, how a boy can inherit the property of their ancestors, in the same way a girl can also have the right to inherit their ancestors property. Okay, they have it is a equal birthright. Okay, see what is the SC ruling. A 3-judge bench headed by Justice Arun Mishra ruled a Hindu woman's right to be a joint heir to the ancestral property is by birth. That is, a woman of a Hindu joint family, okay, they have given the woman's right to be a joint heir to the ancestral property, and this right is based upon their birth, and it does not depend on whether her father was alive or not when the law was enacted in 2005. Okay, on September 9 2005 this law was actually enacted. Okay, so it does not depend on when the law was enacted. Okay, it does not depend on that, and also it does not depend on whether the father of the girl is alive or not. Okay, so it is a right by birth. Okay, so the amendment of the Hindu Succession Act, it gives the equal rights to the girls to the ancestral property. Okay, and it will have a retrospective effect. Okay, so we have to see in detail about the Hindu Succession Act 2005. Hindu Succession Amendment Act 2005, it gave the Hindu woman right to be a co-partners or the joint legal heirs like a male heir does. Okay, so what was this Hindu Succession Act 2005 is, it gave the Hindu woman to be the right to be a co-partners or the joint legal heirs like a male heir does. So what is a co-partner? It is the one, co-partner is a person who shares equally in the inheritance of an undivided property. If there is a property, okay, so they also can inherit the property of their ancestors. They can have equal share. Okay, so the ruling also said that since by birth, okay, the corpusary is by birth, and it is not necessary that father of the corpusner should be living as on 9/9/2005. That is when the amendment came into act. Okay, so it is not depending upon when the amendment came. Okay, it and also the ruling said that the co-partnery is by birth, and it is not necessary that the father of the girl should be alive or not. Okay, so it doesn't matter. So to know more about this, we should know in detail about the Hindu Succession Act 1956 and also about the 2005 Act. Okay, so Hindu Succession Act 1956. So what is this is, the Mitakshara school of Hindu law was codified as the Hindu Succession Act 1956. Okay, so according to this, it governed the succession and inheritance of a property by only recognized males as their legal heirs. Okay, so what is this Hindu Succession Act 1956 is telling us is that succession and inheritance of the property is recognized males as their legal heirs. It does not mention about the female heirs. Okay, and the law applied to everyone. Okay, this law is applied to everyone who is not a Muslim, Christian, Parsi or Jew by religion. So four religions are not included in this act. Okay, and it is applied to Buddhist, Sikhs, Jains and followers of Arya Samaj and Brahmo Samaj. All these other religions are considered as Hindus in the purpose of this law. Okay, so these religions are considered under Hindu law when it is considered regarding the law. Okay, but this law is applied to everyone who is not a Muslim, Christian, Parsi or Jew by religion. So it is not applicable to these 4 religions. Okay, so next is in Hindu undivided family, which we mentioned it as HUF. Okay, so Hindu undivided family, several legal heirs through generations can exist jointly. That is, when a family is there, okay, a grandfather, a grandmother, okay, and they are having 2 child, a boy and a girl, okay, and again they are married and they are having children. Okay, so when you consider this kind of family, okay, so who is considered as a Hindu undivided family is the ancestors, okay, and their wives, mother and their unmarried daughter alone is considered as the Hindu undivided family. Okay, they do not consider the girl heir of the family. Okay, so if this girl is again married, she is not included. If she is unmarried, they will include them in the Hindu undivided family. The legal heirs hold the family property jointly. Next is 2005 law. So what is this 2005 law is, women were recognized as co-partners or joint legal heirs for partition arising from 2005. So from 2005, okay, for the partitions, the women are also considered as the co-partners or the joint legal heirs. Okay, so what does the co-partners is? A co-partner is the one who shares equally the inheritance of an undivided property. Okay, so section 6 of the act also a co-partner by birth in her own right. So what is section 6 of the act is, it was amended that year to make a daughter of a co-partner also a co-partner by birth in her own right. Okay, so by birth she is also becoming a daughter, is also becoming a co-partner. Okay, and the law also gave the daughter the same rights and liabilities in the co-partner property as a son. So whatever the co-partner property a boy inherits, the same rights and liabilities is given to the girl also, and it applies to the ancestral property and to instant succession in personal property where succession happens as per law and not through a will. Okay, so it applies to the ancestral property also in the personal properties where the succession is happening as per the law. The 174th Law Commission report, so it also recommended that this reform in Hindu Succession Act. Okay, even before the 2005 amendment, okay, Andhra Pradesh, Karnataka, Maharashtra and Tamil Nadu has made this change in the law. Already before this 2005 amendment came into force, these states Andhra Pradesh, Karnataka, Maharashtra and Tamil Nadu have made the same change in their law. So next is with previous case reference. Okay, how did the case come about is, so what happened is, while the 2005 law, it gives the equal right to the woman, there were many questions rising, okay, about the in multiple cases there were different questions were arising on whether the law is applied retrospectively. Okay, so the questions regarding whether the right of the woman is dependent on the living status of a father through whom they would inherit. Okay, so it depends on the living status of the father or whether the law applied retrospectively. Okay, so the law, even though the law gave the equal rights to women, there were these questions. Okay, so different benches of the Supreme Court had conflicting views on the same issue. Okay, so in 2015, Prakash v. Pulwati case. Okay, so in that case the SC has held that the benefit of the 2005 amendment, it can be granted only to the living daughters of the living co-partners. Okay, so if the co-partner is living, okay, if the father is living, okay, then the living daughter can have the right. Okay, this is as per September 9, 2005 when the act came into force. In 2008, the SC held the share of father who died in 2001, which also passed to his daughter as co-partners during the partition of the property as per the 2005 law. So same way, in another case in 2018, what the SC has held is the share of the father, but the father was died in 2001 earlier. Okay, so the father was died, but still it gave the right to the daughter during the partition of the property. Okay, so this conflicting views by the benches of the equal strength led to a reference to the 3-judge bench in the current case. So they came out with the new benchmark judgment. Okay, so the ruling now overrules the verdicts from 2015 and 2018. So now they now they overruled the verdicts. Court decision over the case. So what was the decision of the court over the cases? The court looked into the rights under the Mitakshara corpusonary. Okay, so the section 6 creates an unobstructed heritage or a right created by birth for the daughter of the corpuscular. So okay, what is this section 6 is giving us? It gives the unobstructed heritage, and also it is giving the right, it is by birth for the daughter of the corpuscular. It is not given in between. It is given, this right is given to a daughter on her birth itself. Okay, so the right cannot be limited only whether the corpuscular is alive or whether he is dead. It doesn't depend upon it. It is not limited into it. Okay, so where the right is operationalized. Okay, the court said that in 2005 amendment gave recognition of a right that was in fact acquired by the daughter at birth. Okay, so this right was given to the daughter at birth. Okay, the conferral of the right is by birth, and the rights are given in the same manner with instance of corpuscularity as that of son. So now the girl is also getting the right as a son. Okay, she is treated as a corpuscular in the same way, with the same rights as if she had been a son at the time of her birth. So at the time of birth, if she was a son, what they would be given her the rights, right? So the same way as a boy, now the girl is also treated as a corpuscular in the same manner with the same rights, and she is now the corpuscular. Okay, and she can claim for the property. Okay, so now the ruling said that rights can be claimed. Okay, and the girl is treated as a corpuscular in the same way as that, or with the same rights as that of a boy in the family, and they confer benefits based on the antecedent event, that is the event that happened earlier. The Mitakshara corpusonary shall be deemed to include a reference to a daughter as a corpuscular. Okay, so now it can be included, the daughter can be included as a corpuscular, and Supreme Court directed the High Courts to dispose the cases involving the same issue. Okay, because within 6 months the High Court should dispose all these cases involving this issue. So SC directed all the High Courts to dispose these cases. Okay, since they would have been pending for so long years. Okay, government stand. Okay, what was the government stand is this. Solicitor General Tushar Mehta argued in favor of an expansive reading of the law to allow equal rights of the woman. Okay, so he was arguing in favor of to allow the equal rights for women, and he referred to the objects and reasons of the 2005 amendment, and he also said about the Mitakshara law, it contributed to the gender discrimination and it was not okay, right? So he said that the law, it didn't give the fundamental right of equality guaranteed by the Constitution of India. So the new rule came into effect. Thank you. Thanks for watching. Do subscribe our channel and click like button to this video, and join our Telegram channel to get info about the daily current affairs and also to get value added materials. Thank you.